Hello and welcome to Legal Briefs. This is attorney Jeremy Hogan, and today is Labor Day here in the States, which I of course celebrate by working. Working for you, because probably the most important document filed yet in the SEC versus Ripple case was shown to the public just this last week without too much fanfare because it was filed at midnight and right before the end of the fact discovery cutoff, and it is Ripple's motion to compel the SEC to provide better answers to its interrogatory questions. Now, these discovery motions are kind of the black sheep of the legal world, usually handed off to younger associates to handle as they are rather boring and tedious. But not today, my friends, because I have decided to hype the heck out of this motion, and therefore I present Legal Briefs Hype Edition. Welcome to Legal Briefs. Let's get right to it and look at Ripple's motion to compel answers to interrogatories, because this is the first time we have seen this stuff, and believe it or not, it's the most important pleading we have seen thus far. And here's why. Now, Mr. Hinman, just for an example, can say that his statements are only his personal views, but the SEC, as the plaintiff who has decided to file a lawsuit, has to answer questions from Ripple, and those questions are called interrogatories. So Ripple has sent these interrogatory questions to the SEC, and the SEC has responded, and now we are fighting over whether those answers are sufficient. And to explain what interrogatories are and why they are so important, I introduce you to Professor Thien-Vu Hogan to explain Rule 33 of the Federal Rules.
The rule for interrogatories is Rule 33, and interrogatories are written questions, and each party can ask 25 questions. That's in paragraph A1. And what can you ask about? You can ask fairly broad questions, and looking at A2, which is titled Scope, you can see that a party in a lawsuit can even ask questions that ask for the application of law to fact. That's very important here, as we'll see in a bit. And finally, and this is key, looking at paragraph B3, the rules say that each interrogatory must be answered separately and fully in writing under oath. And it's the under oath part that this is key, because that means that these responses are the testimony of the SEC. In other words, these answers can be introduced into evidence, quoted at trial, used during closing statement, etc. Just like the SEC was on the stand with its right hand up in the air. Just imagine her name is Stacey Evans Cabrera, SEC.
And really, as the party that brings the lawsuit, the burden really should be and is on the plaintiff to make its case. Now, in my practice, I represent the plaintiff 95% of the time. I can't just sue someone without really knowing why and being able to spell it all out. When I sue an insurance company, for example, for breaching its contract with its insured, I better have a copy of the contract, know what provision was breached, how it was breached, and what my client's damages are, and I certainly need to know those things after 9 months of discovery. But what we can see here in Ripple's motion to compel answers, or better answers really, to its interrogatories, is the SEC lawyers really struggling to lay out the entirety of its case and not being able to do so with any specificity. Let's take a look at this motion and introduce it with some hype. Ripple's motion to compel. Wish someone would do that with my motions. So, to break down Ripple's motion to compel for you, it's generally asking the court to force the SEC to answer three broad areas of questioning. The first broad area is, tell us, SEC, how are sales of XRP sales of securities? These areas of inquiry are interrogatories 2, 6, 11, 17, 19, if you're looking at it, and they are all phrased in slightly different ways, but they are essentially asking the SEC to lay out its case. The second area of inquiry is about internal and external discussions about the security status of XRP, Ether, and Bitcoin. And the third area is generally about technical issues related to the XRP ledger and decentralization. But let's focus on the first area of inquiry, because the interrogatories ask the SEC, how was Ripple's sales of XRP sales of securities? So these answers, this is it. This is what the SEC is going to prove in court. And so let's take a look at its answers under oath. And here we are looking at Exhibit A to the motion to compel, and this is the SEC's responses and objections to interrogatory number 2. Look at the bottom of page 7. Now I want to give you a little hint. If you are reviewing interrogatory responses for the first time, you are usually going to see about every legal objection in the world to a question. Object to this, we object to that, we object to that. Now I do that also, but the hint here is to ignore them and scroll on down or look on down and look for these magic words, notwithstanding the above objections, blah, 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 blah. And that is where the answer starts, and there it is at the top of page 10. And normally I wouldn't just read with you a page of a document, but this is very important. This is the entirety of the case that the SEC is bringing. This is the evidence that XRP was sold as a security. So let's read it. Quote, these public statements included but are not limited to promises to and discussions of Ripple's own incentives and plans to create an active and liquid trading market for XRP and to develop and foster uses for XRP. Ripple and its affiliates, agents, and executives incentives to build an ecosystem that utilize XRP and be a good steward of XRP. Ripple's significant holdings of XRP and its relationships to the company's financial operations. Ripple's and its affiliates, agents, and executives' actual efforts to create demand for XRP, and statements touting the increase in price of XRP and its availability on digital asset trading platforms. These types of statements, and others of substantially similar sum and substance, were made, among other places, in YouTube videos, tweets, and posts on digital asset discussions fora by Ripple personnel David Schwartz, Patrick Griffin, Arthur Brito, Brianne Madigan, Monica Long, Ashish Birla, Miguel Villas, and defendants Garlinghouse and Larson, though many other Ripple employees made such public statements as well. From 2013 through 2020, public statements posted by Ripple on its website and on its Twitter or YouTube accounts, including periodic updates and the quarterly XRP market reports, emails between Ripple personnel and members of the public discussing Ripple and/or XRP, and in-person conversations between Ripple personnel and members of the public discussing Ripple and/or XRP, such as at Digital Asset Discussion Symposia or Fora. In addition, the economic reality of Ripple's holdings of XRP, Ripple's incentives with respect to XRP, Ripple's offers and sales of XRP, including on occasion at a discount market price, the lack of uses for XRP, and Ripple's case, and there the SEC cites too the current legal action, promises to create uses for XRP, and of XRP itself and its relationship to Ripple, all created in XRP purchasers a reasonable expectation of profit from their purchase of XRP. And that's it. That is the case, under oath and in its entirety. So let's briefly unpack that. First, the SEC alleges that Ripple was involved in creating a liquid market for XRP. Now I think we all understand why it would do that, because its use case for XRP requires a liquid market. And also that Ripple promised to create uses for XRP. That's all kind of the first thing that the SEC is going to prove. Second, the SEC is alleging here that Ripple attempted to manipulate the price of XRP. Now we all know that Ripple failed in this. Nothing Ripple has done pretty much has ever really had any obvious effect on the price of XRP. But the point is that it tried. And the SEC lists specific people that tried to manipulate the market and did so on Twitter and YouTube. I didn't know YouTube was such a powerful business for them. Although, look at what has happened since this motion was filed last week. Boom. And finally, the SEC states that XRP did not have any use and therefore purchasers were looking to Ripple to find uses for it, and that would increase the value. So, putting aside whether the SEC has proven or can prove its case with these facts, the question that this motion brings is the answers good enough, or are the answers good enough? Now, to see what the law says on this issue, as to completeness of answers, we go back to our legal expert, Thien-Vu Hogan.
Legal expert, exactly. Or if you're used to how Jeremy says it, exactly. Looking at Ripple's motion, top of page 2. Rule 33 requires the SEC to answer each interrogatory separately and fully, and in a manner that is specific as possible and not evasive. Rule 33 requires full and complete responses to interrogatories in order to minimize uncertainty concerning the scope of the SEC's claims.
So the question is, did the SEC answer the question fully and as specific as possible? And I would say that the answer to that question is no. Well, that is the heart of the case, and it is not specific enough. I mean, at one point in answering interrogatory number 8, the SEC provides a link to evidence, and it's just a link to Twitter in general. When I clicked on the link, which is supposed to be to a piece of evidence, I just saw a picture of my face. That's some ugly evidence. So for that reason alone, I would predict that Ripple's motion to compel better answers to interrogatories will be granted in large part. But that being said, it's probably in the SEC's best interest to amend its answers because they aren't very compelling to me and obviously not very specific. And if I was representing the SEC, I would want to amend these answers with an eye towards summary judgment. And I think it will be allowed to do so, or we should say will be forced to do so, because discovery has not been completed yet. There are still the depositions of Brad Garlinghouse and Chris Larson this month, and also expert witness testimony. So at the end of the day, I think there will be amended answers here, and I think the SEC will be forced to show its hand, and by that I mean not just a hand drawn by a little 4-year-old, but a detailed Rembrandt hand with joints and wrinkles and such. And we learned one more thing from this motion, which I want to touch on briefly, which is a big problem, not only for the SEC, but really for the court as well. Looking at the bottom of page 2 of the motion, quote, the SEC responded that every offer, sale, and distribution of XRP by defendants over an 8-year period, which defendants estimate includes, but is not limited to, approximately 1,700 contracts, close quote. Wait a minute, so because the SEC waited over 8 years to bring this action, we're looking at over 1,700 sales of XRP to various entities by various entities with different arrangements, and many of the resales made to non-United States exchanges and entities. So forget about whether the 1,700 sales were investment contracts. How is the court going to analyze jurisdiction over all of these sales in order to analyze damages? Now, I have no idea how this is even possible, and I'm glad it's not my job to figure it out. What a mess. In any case, thanks for watching, and thank you to my 12-year-old daughter for doing our hype videos for us. She's really good with the video editing. Love you, baby. And let's end with this.